Parviz Ravi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, fired after giving notice to quit. In California, employment is presumed to be at will unless stated otherwise in an employment contract. At will employment means that either the employer or the employee can terminate the employment relationship at any time, for any reason, or for no reason at all, as long as the reason is not illegal. Under California law, you do not have to give notice and may quit your job at any time. However, some employees give their boss 2 weeks' notice before leaving a position. In California, your employer has no legal obligation to honor your 2 weeks' notice if you decide to leave. You might wonder why your employer would fire you if you already gave notice of your departure. There are several reasons your employer may wish to do so. For example, they may have an applicant ready to begin employment and do not want to pay 2 employees for one position. Or they may feel that the working relationship is no longer productive, that the employee has given notice, especially if the job involves long-term projects or objectives. However, there are some cases in which California law protects you from being fired, including during your 2 weeks' notice before quitting, and such firing could lead into wrongful termination. For example, if you're leaving your job because the workplace is hostile due to harassment and you inform your employer of this reason, your termination could be unlawful retaliation. If you have an employment contract that requires you to give notice and work 2 weeks before leaving, your employer may breach the contract by firing you. If you give your notice due to medical condition or because you're pregnant and plan to leave work to raise a child, it's typically a case of wrongful termination if your employer fires you during your 2 week notice. Those with a medical condition and pregnancy are members of a protected class in California's workplace anti-discrimination laws. Keep in mind that one of the main reasons why employers will not fire employees after they gave notice is unemployment benefit. If you quit your job voluntarily, you are not eligible for unemployment benefits. However, if your employer turns around and terminates you, you might qualify for unemployment. This is because your employer fired you when you were able and willing to continue working for a period of time. In any event, even if you're terminated after giving notice, you may still be eligible for unemployment benefit. Follow the appropriate steps to file a claim with the California Employment Development Department, EDD. If you believe that your termination within the notice period was unlawful, you may have grounds for legal action. Remember, your rights as an employee are protected by law, and you have the means to take action if your employer fails to comply with the regulations. So stay informed, know your rights, and advocate for fair treatment in the workplace. If you have any question on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.